Karnataka's organized crime law, Lankesh murder and an High Court order. On April 22, Karnataka High Court ordered dropping KCOCA charges on against Mohan Naik, a key accused in the murder. Naik 50 is also accused of being an integral part of an organized crime syndicate that shot down Lankesh. Karnataka Control of Organized Crime Act KCOCA 2000, a stringent law modeled on the Maharashtra Control of Organized Crime Act 1999, is at the center of controversy in Karnataka relating to its use in the case of journalist Gauri Lankesh murder in 2017. On April 22, Karnataka High Court ordered dropping of KCOCA charges against Mohan Naik, a key accused in the murder. Naik 50 is also accused of being an integral part of an organized crime syndicate that shot down Lankesh. As the BJP-led state government delayed over mounting a challenge against the High Court order, slain journalist sister Kavita Lankesh has moved the Supreme Court over the dropping of KCOCA charges. At the heart of the controversy is a clause under which any person arrested for an organized crime, even an abettor, is considered a member of the organized gang involved in the crime. If any of the persons arrested for the crime has one or more preceding charge sheet for similar crimes in the previous 10 years, the law and its use. KCOCA was legislated during the tenure of a Congress government in 2001 and received presidential assent in December 2001. Among its provisions, it allows police to hold arrested persons in custody for 30 days and in judicial custody for up to 180 days before filing a charge sheet, unlike in other crimes where the maximum allowed duration for such custody is 14 and 90 days respectively. In KCOCA cases, bail can be rejected based on prima facie evidence of involvement of a suspect in crime. A confession before a police officer can be treated as evidence and a legal telephony interceptions are given credence. Initially, KCOCA was used very sparingly since the setting up of special courts for KCOCA cases were delayed. In the early 2000s, the then Congress government was reluctant to use it since the Prevention of Terrorism Act POTA 2002 was still in force then. It was repealed in 2004. The law was used by the Karnataka police against a gang linked to underworld don Baniji Raja, who was arrested for the December 2013 shooting of trader R.N. Naik in Ankola in coastal Karnataka. Although there was no charge sheet against Vanaje Raja himself when he was deported from Morocco in 2015, police invoked KCOCA against him on account of the multiple charge sheets faced by many other arrested for the shooting. These cases are currently in special KCOCA court. There are 17 KCOCA cases pending in the state. In the Gauri Lankesh murder, a special investigation team invoked KCOCA in 2018. The SIT has arrested and charge-sheeted 17 people linked to right-wing groups who created a syndicate to carry out killings and attacks on critics, preliminary in Karnataka and Maharashtra during 2013-18. The controversy. On April 22 this year, a single judge of the Karnataka High Court, K.S. Mudgal, ordered the dropping KCOCA charges against Naik, an alternative medicine practitioner who allegedly helped those involved in the killing of Gauri Lankesh, on the grounds that the law was not applicable to him since he had no prior charges. The High Court order quashed the August 14, 2018 order of the Bengaluru Police Commissioner invoking KCOCA in the murder case with specific reference to Naik, and also ordered the quashing of charge sheet under KCOCA against Naik on the ground that he was not involved in continuing unlawful activities as defined in KCOCA. The court rejected the plea of the Karnataka police, who cited that KCOCA provision that a person is considered involved in continuing unlawful activity linked to a crime syndicate if any person in the group except accused of a crime faces more than one charge sheet for similar offences within the preceding period of 10 years. Courts on the clause. In 2019, Karnataka High Court ruling in the case of Class 12 examination paper leak and the definition of continuing unlawful activity under KCOD does not mean that more than one charge sheet had to be filed in the preceding 10 years even against abettors of the organized crime. A special KCOCA court has held the view in Gauri Lankesh case that the provision of KCOCA Act can also be invoked against the abettor who assisted and abetted the continuing unlawful activity of organized crime syndicate. Referring to MCOCA case, the court said even if a person is not having any direct role to play as regards of the commission of an organized crime, if the nexus either with an accused who is a member of organized crime syndicate or with offense in the nature of organized crime is established, that would attract the invocation of section 3(2) of MCOCA. The provision of MCOCA and KCOCA Act are similar. Thank you.